All right, we're about to begin our continued preliminary examination. And that will complete our day, hopefully. All right, we're ready to go. I'll start the record. Laura, you might want to come in and help me on this. We'll see how this goes. I don't know how I'm gonna go.
That first yellow chair.
Good afternoon. Please have a seat. We're a little early. It's 2:57. I guess there's no harm in that. Was your son going to come back again today?
Yes, he's coming back.
Should we wait till 3? Okay. We'll let the clock tick a little bit. I will indicate, well, I'll call the case. This is file 23915FY, People versus Rosalind Ray Keenan. Ms. Keenan is charged with resisting obstructing a police officer, which is a felony punishable by up to 2 years imprisonment and a fine of up to $2,000, and with driving suspended. That's a misdemeanor punishable by up to 93 days in jail.
Wow. Just listen to the weight of those charges as the judge reads them out. A felony for resisting and obstructing, plus driving on a suspended license stacked on top. It might sound minor, but the reality is life-changing, up to 2 years in prison. This is why these hearings matter so much. One decision in this moment can shape everything.
And a fine of up to $500. It carries 2 points on your driving record, and it requires that the license be suspended. I apologize, I'm losing my voice at the end of the day here. That sometimes happens. Yeah, I talk too much. Anyway, yesterday we were here for a preliminary examination. We had another case that went first involving a child witness and took quite a bit of time, so we didn't get to this until after 3 o'clock. Ms. Keenan had previously indicated she did not wish to have an attorney, and there was no attorney on her behalf at that time. Prosecutor David Marvin was here yesterday, and there was one or more police officers that were here yesterday prepared to testify. We didn't get very far. We started to go through the particulars, but Mr. Marvin made a plea offer. I want to repeat that, Ms. Keenan. He offered to dismiss the felony charge of resisting and obstructing. He offered to dismiss the charge of driving suspended, which would not go on your driving record, for a misdemeanor plea to attempting to resist or obstruct a police officer. That's a misdemeanor. It's punishable by up to 1 year in jail and a fine of up to $1,000. He offered to then defer the sentence for 6 months, and if there were no other issues or concerns, he would consider dismissing the case.
Here's where it gets interesting. The prosecutor offers her a lifeline. No felony record, no suspended license charge, just a reduced misdemeanor that could even be dismissed after 6 months. That kind of generosity in a resisting arrest case is almost unheard of. But there's always a catch. You've got to play by the rules, show good behavior, and most importantly, understand the system you're up against.
I was not able to be here this afternoon. He stopped in this morning and confirmed to me that his plea offer was still open to dismiss the felony charge and the driving suspended charge for the plea to attempting to resist or obstruct a police officer. We were talking with Ms. Keenan yesterday. I found that she was in contempt and ordered that she go to jail, and she did, and we're here today. We were trying to establish whether she wanted any legal assistance in this matter. So, Ms. Keenan, you're the same person that you were yesterday with the same reservations and concerns. Is that correct?
Thank you. Some things like proof that the license shouldn't have been suspended, and they did reinstate them in Indiana.
All right, well, he's willing to dismiss that charge.
I think that's why, because I showed it to him.
All right, well, maybe so. He said you and he had several discussions. So let's see if we can get to square one here. Do you want an attorney to assist you in this matter? I can appoint one and we can set it for further hearing. I don't want to force one on you, but I do think you could benefit from having counsel. It was clear you didn't understand the difference between a criminal case and a civil case.
This part shows the real danger of walking into court without a lawyer. Just yesterday, she refused counsel, got confused between civil and criminal law, and ended up in jail for contempt. Imagine a single misunderstanding costing you a night behind bars. The judge's tone says it all. He doesn't want her stumbling blind into a felony conviction. He's practically begging her to accept legal help.
No harm in that was your jail. I won't be offended if you tell me that you want to have an attorney, in which case I would set this matter for further proceeding out 2 weeks, which would be July 5th. How would you like to proceed, Ms. Keenan?
Thank you. So if I choose to get an attorney, can I have 2 weeks and then nothing else will be brought up today?
Correct. Now, you could enter the plea to the misdemeanor offer that Mr. Marvin made today. But I do think you could benefit from having an attorney to assist you with this, in which case I would continue it to the 5th of July. That's 2 weeks from today in the afternoon. Usually it'd be on a Tuesday, but that's a holiday. It would be 1 o'clock on July 5th.
I'm going to be still having to stay at the county jail and wait till...
Well, let's talk about that. No, you posted a $10,000 cash or surety bond. However, you've not agreed to be fingerprinted. So as soon as you agree to be fingerprinted, you can be released from jail. Otherwise, you're going to sit there.
Now the tension shifts. She's worried about being stuck in jail while she waits. The judge is blunt. She can walk free the moment she agrees to fingerprints. It's a simple legal requirement, yet she resists. This is one of those self-inflicted wounds we see all too often in court. People making their situation worse by refusing basic procedures.
All right. Would you like me to appoint an attorney for you?
Yes, if you appoint an attorney, defense attorneys.
Yes.
Okay.
Here's your son. All right, I'm going to appoint an attorney, which I think you could benefit from. I guess you can always say later, I don't want one, but at least like you have an opportunity to consult with.
Finally, she agrees to have an attorney appointed, and it's a huge relief. Even the judge's tone softens. Having counsel isn't just about navigating legal jargon, it's about protection. A lawyer acts as a shield, keeping you from making emotional, split-second mistakes that can carry life-changing consequences.
Number, it could be a he or a she.
I have a question.
Continue to.
If I have an attorney, I would like to be able to not be able to see him any sooner than Friday, because I want to be able to go
That's fine.
to a couple appointments for my dental and things that I want to
I'll
do.
give you their name or number. It could be a he or a she. Continue to July 5th at 1 o'clock for prelim. Bond is reinstated.
You mean that the bond was canceled?
No, it wasn't canceled.
Oh,
Under condition, the defendant be fingerprinted. The original complaint from the day of the arrest said that you did not comply with fingerprinting at that time. They attempted to do the fingerprinting again yesterday and they weren't able to do it. And I was advised by corrections staff that as of today, you still declined to be fingerprinted. So as soon as you agree to be fingerprinted, you can get out. If you don't, you can sit there for 2 weeks and we'll discuss it next Friday.
But here's the twist. She still refuses to give fingerprints. And without that, the bond means nothing. She stays locked up. It's painful to watch, because her freedom is sitting right there, just one simple step away, and she won't take it.
July 5th. In the meantime, I believe Mr. Marvin's misdemeanor offer is going to remain, but you're not to be released until you complied with the booking process, including photo and fingerprints.
Excuse me.
Yes, sir.
Today
Yes, ma'am.
I think it was today, or maybe, because I slept a lot, so I don't even, anyway, they booked me and took my picture.
All right, well, the
Is that
picture's
good
done.
enough?
That's good enough, but you
That's
have to
good
agree to
enough?
the fingerprints.
Oh, I still have to do
Yes,
it?
and you can decide whether you want to do it. If you don't, that's
Well,
up to
I'm
you.
gonna do it,
All right.
because I appreciate your offer, thank you.
At last, she gives in. She agrees to the fingerprints, and you can practically hear the judge exhale. After all the defiance, the standoff breaks in a single moment of cooperation. It's a dramatic turnaround, stonewalling 1 second, conceding the next.
They'll take you back to the jail. If you finish the fingerprint process, you can pick her up at the jail. We'll give you the paperwork before she goes about who her court-appointed attorney is. After Friday, I want you to call them and make an appointment to discuss this matter with them. All right, you're good to go. We'll take another shot at this on July 5th. You will have been fingerprinted by then, and Mr. Marvin will be back at that time.
So, you wanna meet me at the jail? Come and get this, please.
You want
Yeah.
to hand it to him?
Yeah, he can have that stuff, and he can come meet you at the jail. You should be booked out by 4 o'clock.
This.
Yeah, it's just this one, wait, maybe I have it. It's the pin number. Oh,
Just all.
yeah, there it is.
So is it okay for me to give it to him?
Oh, yeah, I need this at the jail.
Here,
So at the jail, I'll be down there soon, right? Or am
He's
I
gonna take you
leaving
back right now.
Yes, I just gotta wait for their paperwork.
The judge closes the hearing by setting the next court date, stressing the importance of contacting her new attorney, and outlining the release process. The exchange underscores just how thin the line is in court, between defiance and freedom, confusion and second chances.